has been passed by a Kerala local court that has virtually linked sexual harassment to the clothes a woman was wearing at the time or wears just generally. Granting anticipatory bail to writer and social activist Civic Chandran in a sexual harassment case, the Kozhikode Sessions Court observed that the charge under Section 354A, which is sexual harassment, would prima facie not be accepted, not be attracted if the woman was caught wearing sexually provocative dresses. This has, of course, invited shock and outrage as it effectively blames the woman, the victim, in cases of assault and sexual crimes, taking away the onus from the assaulter. In fact, there are many aspects of this case that are shocking. The accused had the bravado to furnish photos of the complainant with his bail plea. And the court then said that sexual harassment cannot be made out if the woman is wearing sexually provocative dresses after looking at those photos. And the accused, who was booked under Section 354A, 2, 341 and 354, was granted anticipatory bail. Several aspects of the order and observation have raised eyebrows. I just want to take you through those because it's not, the clothes issue is not the only one. The court has said that for sexual harassment, there must be physical contact and unwelcome explicit sexual overtures. There must be a demand or request for sexual favors. I really doubt that's how sexual harassment works, that somebody demands or requests a sexual favor. There must be a sexually colored remark. Again, not really how sexual harassments often go. Photos reveal that the complainant is exposing to dresses that are sexually provocative. Section 354A will prima facie not stand. And the court has also gone on to say that it's impossible to believe that a 74-year-old physically disabled man could forcefully do things. So the big debate that is now coming up, this is the shocker that has come in from the Kerala court. And is this not going to make the fight of sexual assault and crimes victims harder if the onus is going to be put on them yet again?
Judgment on this case should be awaited from the honorable courts. But meanwhile, the statement and thought process around women clothing being provocative is always a weapon used to whitewash the pervert mindset. Clothing speaks to a man to invite, and he understands that language. But a woman is screaming a N-O, capital no, and he doesn't understand that. This is extremely regressive statement and very inhumane.
कई बार हमने देखा है कि बहुत ही आश्चर्यजनक जो फैसले या स्टेटमेंट या बयान कोर्ट की तरफ से होते हैं जो स्त्रियों के सम्मान को बिल्कुल ही नीचे गिराते हैं, उनको एक तरह से कहते हैं कि जो स्त्रियों की जो सेफ्टी है उस पर एक वार सा प्रहार सा ये बयान करते हुए दिखते हैं.
Let me go across to advocate in the Supreme Court, Shivani Dubey joining us. Sandhya Raju is an activist. We'll be joined with more guests in just a bit. But Sandhya, I'm coming to you first up. There have been occasions on which very, orders or observations that raise eyebrows have been made, especially in context of sexual crimes. What is your prima facie opinion on what the court has said in this case? Has it effectively linked how a woman dresses to whether a man can sexually assault her?
See, what is coming out through this judgment is the prejudice which many, the patriarchal mindset and the prejudices which men have against women, many men have against women. It is, we live in this a kind of mirage where you say that Kerala is a place which is very
highly educated and literate and
very favorable. The environment is very favorable for women because of its education, because of its literacy. But you have a human rights activist, supposed human rights, Dalit rights activist, actually, whom we presume that will be more sensitive towards gender issues, actually assaulting or actually causing sexual harassment at workplace, and then coming out and saying that I have not done something like that.
No, that's fine. That the accused has the right to defend themselves. Let's focus on what the court has said. Do you believe that the long fight that we've been fighting as women, and many men have been fighting with women, that you cannot blame the victim on how they were dressed?
The judiciary, which is supposed to keep abreast about the the latest readings in law. There has been an amendment. There have various judicial decisions from the Supreme Court, from the High Court, constantly coming out, and this particular decision has totally overruled or totally omitted whatever judgments have come. It's more like, God, let the Supreme Court say anything, let the High Court say anything. We are not bothered. This is what it is, and this is how I will look at it. It is more like a pushback against women's rights. It's mostly a
But
pushback
this is hardly,
against
I mean,
women's
this is
rights
not
by the
even,
judicial.
this is not even like some sort of a battle of women's rights. I mean, this is just what the law has to do and what the law has to say. It's not about what we want further. But anyways, Ashwini Dubey is on the show. I've also got Mrunalini Deshmukh, who's also an advocate. But Ashwini, I want to ask you this first. Does this case, as Sandhya was saying, not show that there is indeed a problem when it comes to our courts, especially lower courts, where they just, they're not in line with our laws and the standards we want to set in sexual crimes cases?
Shivani, thank you for having me here. Shivani, judge has to pass order on the basis of evidences available on the record.
Yeah.
What is sexually provocative and what is not?
Exactly.
And what is the degree of sexual provocation? What are the parameters to decide the sexual provocation has not been defined. Right to Article 21 of the Constitution of India says the right to wear is a fundamental right. And that too, at a time when Section 354, 354A, 354B has been inserted after the Justice Verma Committee's recommendation and after Nirbhaya incident, when major case took place in Criminal Procedure Code and offences against the women was certain things were enhanced in the Criminal Procedure Code. Judge, instead of passing order on the basis of evidences available on record, working and passing order on the surmises and conjectures, I think this is wrong. One. The second, judge has not to pass order considering the age. Judge has not to pass order considering the what is the dress was wearing, the victim was wearing. But
yeah, right. No, but that I get. I don't think anybody can defend it. But Ashwini, the question I'm asking you, sir, is this not a reality that there's a patriarchal mindset amongst the judiciary system?
That is why the appellate court has to look into it. If you remember, in a landmark judgment, skin to skin judgment, the Supreme Court has come forward and has said what was said, set aside the decision passed by the Nagpur bench of Bombay High Court. Similarly, in this case, the top court must look into it. The order passed by the judge is not based on the evidence, but judge has gone beyond what the law says.
Yeah, so that's what I'm asking. Okay, Mrunalini, come here. Is there any aspect of the law that justifies these observations and orders that the court has made on the basis of the clothes, on the basis of the age of the accused, and has given the anticipatory bail? I'm not objecting to the bail being given, but is there any section of the law where the court can take this liberty?
See, the court, the judge, and I'm going to talk as a lawyer, neither defending or going against the order or the wordings of it. The court has to decide a case based on the facts which are there before the court. And that could be the defense argument and the argument of the prosecution in the case of this, maybe the victim who is subjected to sexual harassment. Now, the issue is the court in its wisdom, rightly or wrongly, and I'm not going to justify that, has felt that in the given set of circumstances, there is no case made out, or it's a case for a bailable thing and the bail should be granted. Now, having said this, was there a need to say that she was wearing provocative clothes or sexually provocative or seductive clothes, as a result of which the man may have done it? At the same time, the judge says that the man is incapable of doing it because of the age. Now, there is inconsistency in these two statements. Shivani, have you understood that?
Absolutely.
There is inconsistency. On one hand, you're saying that somebody has worn sexually provocative dress, and on the other hand, you say that the 74-year-old man is not able to do that. So, which of the two is correct? The dress?
Exactly, because at one level, you've justified that if a woman is wearing sexually provocative clothing, then she is fair game. You can harass her. That's the problem, actually. That's the fundamental problem. And that the man may have done it.
But in the same order, he says, because the gentleman is 74 years old, if I may call him a gentleman, is a 74-year-old person.
He couldn't have forced himself upon the woman.
Incapable of doing it is something which is going beyond the realm of justice which is there. You can say as a judge that the facts which are placed before me do not make out a case of such a big thing, and that is why the bail should be granted. But by adding and justifying by these things, the court has raised a lot of debate where you and me are now discussing. A lot of debate on the sensitivity with which the judiciary should also deal with these
No,
cases.
Madam, Mrunali, can I say, this is not even about being sensitive. This is not that, that fine line. Did the judge not think that the moment you talk about the victim's clothes, you are victim shaming and victim blaming? What is the consequence of the clothes she was wearing?
So we understand that the woman has a right to wear what she wants, whether it's a hijab or whether she wants to wear a particular kind of a dress. That is her right, and nobody can take that away. Now, to what probably has gone wrong in this entire judgment is to adduce the blame on the victim, as you rightly said, shaming the victim because of a provocative dress, as quote unquote him, we don't know what it was at that point of time. And to say that as a result of which this man was, what was he trying to say, tempted to do it?
Exactly. I mean, this is just setting such a bad causal relationship between sexual harassment and why it happens.
Shivani, is that a justification? Somebody comes, does it give a man the liberty, even if a woman is in a very provocative dress, to do what probably he feels like doing without the consent of the woman? I'm sorry, he cannot do that. So there is no question of saying that because she was wearing a sexually provocative dress, that is, he could have well justified by giving a bail by saying that in the facts of the circumstances, I see no reason why a gentleman of this the person could ever have attempted anything, say because of his age or because of his disability.
Sandhya, I want to come to you on the other finer points, because I find it quite horrifying, some of the other things that I've also said. And I have no qualms in accepting that as a woman, I have been through unwarranted advances in my life. I don't think any woman goes through the age of 17, 18 in any part of the world without going through this. So it's not a surprise. And the judge has said things like there must be a demand or request for sexual favors. I don't understand which person who's trying to sexually harass you, molest you, makes a demand or a request. I don't think the judge understands how sexual harassment works. I'm sorry to say. He's also gone on to say that there must be a sexually colored remark. No, people who harass you sexually often don't talk about anything sexual.
He's gone totally on a tangent.
Mrunali, please let Sandhya come in. Let Sandhya come in.
He's gone totally on a tangent on the concept of sexual harassment. His ideas are totally misplaced, and he has not. I mean, he has also not really understood the fact that if the woman says that it is sexual harassment, it is sexual harassment. That is the if she feels that his attention, the abuser's actions were intended to sexually harass her, that means that it is sexual harassment. He completely missed that entire underlying concept. So this entire, I mean, I would say that we talk about a lot of gender sensitization trainings and things like that throughout for each stakeholders who are dealing with women, and I most probably gender sensitization trainings have been given through the academies to judges. But the thing is, what we'll have to seriously think about what is the gender sensitization training which is being given to the
no, I think there is no leeway of sensitization. I think there needs to be accountability, but I'll go to Ashwini on that in just a bit. One second, Mrinalini, you also wanted to come in on this because I'm just horrified as a woman that I don't think people understand how sexual harassment works, especially when there's a power equation.
Absolutely. I think that is the basic premise on which these cases have to be decided, where there has to be that the victim is at the receiving end and the victim is likely to be subjected to the sexual harassment by her superior. Now, where this equation is not, I can also tell you one more thing, Shivani, and just to give sort of credence to what the judge has said. a order which is passed by the court has to be a reasoned out order. It cannot be just that I'm granting bail or I'm rejecting bail. There have to be reasons assigned to it because it may go to the higher forums. So for him to make the case to grant bail to the husband to the man concerned, he has made all these remarks without realizing that you can grant him a bail because that's within your discretion. But by making such remarks in your orders, you are obviously victim shaming. You're obviously not understood that the laws which you are deciding. You can grant him bail. I'm not saying that.
Yeah, absolutely.
But
nobody is objecting to that. And there is an element where the victim has also been questioned on why she delayed the complaint. I don't want to get into that debate because that's a completely different debate. But you know, there is a problem when people don't understand. I think maybe this is a mindset where amongst men there is a culture that okay, यही तो किया है बस, थोड़ा इतना सा ही तो बोला है या इतना सा ही तो टच किया है, इसमें क्या है? इसके लिए कोई sexual harassment का केस होगा क्या? That is the problem. So and then to set these parameters, I don't think this is part of the law that there must be a sexually colored remark. I don't think that happens before sexual harassment or even before a rape. Unfortunately. Anyways, but I mean, shocking as it is, Ashwani, my last question to you is, what is the recourse to the victim in this case and what is the larger accountability that can be set when such orders are given? Which set a bad precedent.
Shivani, parameters have already been set by the top courts in a cases of sexual harassment, be it the Vishaka judgment, be it the Mukesh, be it the Modha Kotwal or certain other judgments. The question here is, Shivani, I do agree with you. That judge has to see the evidences. Giving bail is a discretion of the judge, but not making the comments which directly or indirectly outraise the modesty of the women. Maybe there may be some wrongful malicious prosecution that may be decided at a later stage. At a bail stage, you have to see whether the prima facie evidence is available and the ingredients of the offense is made out or not. Bail you can give. But making this kind of remarks is all of course shows something where the.
So what can be done, Ashwini? What can be done, both in this case and in a larger context?
They see the only thing is since the bail has been given, this kind of remark should be expunged immediately. And this observation, the observation with regard to the modesty of the women, observation with regard to the wearing the clothes, which is a fundamental right under Article 21 of the Constitution of India, that observation must go. Rest the court has to decide because CRPC provides a judge power to give bail. And that too, under section 354A, Shivani, let me very frankly tell you, Mridalini ji is here, that's a valuable offense. But only thing is the remark made by the judge
is the problem. No, I'm not objecting to the bail, frankly. We are not discussing the merits of the case either. We are just discussing, as you very rightly said, Ashwani, at the bail stage, what was the need to kind of give a clean chit to the accused? This is not the trial, right?
That's very true. And that is why, Shivani, 30 seconds.
Yeah.
Physical contact and advances involving unwelcome and explicit sexual overtures. This is 354A. A demand or request for sexual favors, be it in front of somebody, be it not in front of somebody, showing pornography, making sexually colored remarks. The law covers the wide ambit of facts that constitute sexual harassment. That will be decided in this case as a later
No,
stage.
but explain this to me. Explain this to me. All of these may constitute sexual harassment, but all of them doesn't happen in one case, right? So if this case, let's say there was not a sexually colored remark or, you know, not an advance made for sexual favor, that doesn't mean that harassment didn't happen.
One minute, Shivani.
Yeah.
This is only a bail stage. The evidence is still not on
Exactly.
record.
Yes, absolutely.
Not yet commenced. So how could a judge make such remarks as if it's like saying that, okay, buddy, you've done nothing about it and don't worry. And this is the woman who's responsible for that. That is a kind of message that goes. And I think that's
okay.
a good trend. And that's not a healthy trend in such cases. It really gives a setback to the women's protection and the security fight that all of us here are talking about.
It actually gives a setback also to the internal complaints committee hearings, which will be henceforth, taken up, because the committee members will feel something like this is okay, acceptable, because the judges, there have been district judges ruling which kind of says this,
Yeah, no,
so
of course,
it gives
this
a pushback
precedent
against
can percolate to different levels. Absolutely.
People will refrain from going before the internal complaints committee under the act, because they'll fear that, I mean, they'll start they'll believe that, they'll feel that, they may not be believed what they are
What
saying.
they're saying,
So
or what
this entire
constitutes sexual
burden of
harassment. I understand.
Yeah, so the
Unfortunately,
entire burden of-
I've run out of time. I do thank all of you for joining us.